Well, hello and welcome back to my channel. My name is Joanne. I'm the learner lawyer. This is everything on this channel is my own opinion. I suggest that you research and come up with your own ideas. It's easy for channel creators to say, I know everything and I'm always right. I'm not always right. First to admit it. So today was the day that Crikey or private media had their first court appearance against Lachlan Murdoch. So interestingly, also the courts have released the documents, so we can actually look at before we get into the day's events and what's happened today. They have released today, interestingly enough, and my computer's gone really slow. It's feeling a bit old like me. They've released the defense and the reply, so we can actually see what actually was filed in court. So the defense was 14 pages. So this is a federal court filing of a defense, and it's Murdoch versus private media, Lachlan Murdoch. So the first, second, and third respondents, together respondents without admissions, adopted defined terms used in the applicant's statement of claim. So they're all joining together, and I think they're using the same lawyer or the same law firm, and therefore, because they're using the same law firm, and therefore they are banding together and doing this. So let's have a look at this. So this says, so this is their defense that they filed. So their factual background. So they're saying on the 3rd of November, the United States of America conducted its 59th presidential election. Joseph R. Biden won the 2020 presidential election. Facts. Particulars that Biden won 51.3% of the popular vote. He received 306 electoral college votes reflecting that. He won the majority of the votes in the following states. So they go through and list all the states. He won the majority of votes in the 1st Congressional District of Maine, and 3 of Maine's 4 electoral college votes were proportionally assigned to him. He won the majority of votes in the 2nd Congressional District of Nebraska, and 1 of Nebraska's 5 electoral colleges votes. Hello, physics down under. Whom among us needs facts, particularly in the media? Well, this is where the title is ironic, because one of Lachlan Murdoch's complaints is that Crikey or private media is mocking him in the media. Yeah, I know. I mean, that's quite interesting. We'll have a look at that. So it says that point 3 is Donald Trump lost the presidential election, that the results of the 2020 presidential election were certified by the Congress of the United States on the 7th of January 2021, and President Biden was therefore elected as the 46th President of the United States. Allegedly not physics. Point 3 might be salty. I think so. You're going to find, so this is their defense. And then, because I couldn't watch it because I was actually working, but we're going to see what all the reporters have said about today. And then we're going to have a look at what Twitter says. And then we'll get onto some Friendly Geordie stuff as well, because he's on interest. He had a day in court as well. So yes, point 3, Donald J. Trump lost the 2020 elections. Hello, Livadandra. My legs are just very sore. So Mr. Trump refused to concede the presidential election, alleged without any reasonable basis that was stolen by reason of widespread voter fraud. Fox News is the #1 cable network in the United States of America and reaches approximately 200 million people per month. Fox News is operated either or directly through its subsidiary by Fox Corporation. From around the 7th of November 2020, hosts and guests of Fox News repeatedly cast doubt on the outcome of the presidential election and directly or indirectly promoted on air the allegations without reasonable basis of voter fraud made by Mr. Trump the false claim that President Biden had not legitimately won and Mr. Trump had not lost the 2020 presidential election. Reasonable. This is the 20 when has reasonable. Point 9. At no time to date have Rupert Murdoch, the Murdoch family, as owners of Fox Corporation, or the applicant, Lachlan Murdoch, publicly repudiated the claims made by hosts and guests of Fox News alleged in the preceding paragraph. Whoa, they've gone out guns blazing. On the 6th of January 2021, a group of supporters of Mr. Trump violently stormed the Capitol in Washington, District of Columbia, whilst the Congress of the United States of America was in session in an effort to stop the certification of President Biden's victory in the 2020 presidential election. As a consequence of the violent insurrection referred to in the preceding paragraph, members of the Congress of the United States were forced to flee in terror from the Capitol. So physics, most of them did not. The certification of the result of the 2020 election was delayed to the 7th of January 2021. Mark Meadows was the chief of staff to Mr. Trump as of the 6th of January 2021. On the 28th of June 2022, Cassidy Hutchinson, former senior aide to Mr. Meadows, gave evidence at the public hearings of United States House Select Committee on the 6th of January riot. Ms. Hutchinson's evidence was relevantly to the effect that on the 6th of January 2021, Mr. Trump was aware that his supporters proceeding to the Capitol building were armed and had violent intent, wanted to lead his supporters, and had attempted to grab the steering wheel from his driver when the driver refused to take him to the Capitol. Ms. Hutchinson's evidence was given overnight or early morning morning Australian time. Ms. Hutchinson's evidence was widely discussed in the international media and was the immediate impetus for the publication, the subject of this proceeding, by the respondents. At around 8 a.m. on the 29th of June 2022, the second respondent, Mr. Keane, reported to the third respondent, Mr. Frey, that he'd seen evidence of Ms. Hutchinson and that he should write about it. Mr. Frey considered the story to be important to Australia and international audiences, and given the high level of interest in his testimony, felt that expeditious publication was necessary to keep pace with the political news cycle. Mr. Frey was aware that Australia had an editorial advantage given the time zone. Mr. Frey agreed that Mr. Keane should write the story. At the time Mr. Keane wrote the article, the subject of this proceeding, he had extensively university qualifications in history, including the PhD, had extensive experience working in the Commonwealth Public Service on Australian media policy. So particulars. Mr. Keane worked on drafting, passage and implementation of media regulatory reforms in 2006 in his role as a public servant in the then Department of Communications, Information Technology and the Arts. This process involved extensive interaction with and exposure to media companies, including News Corp, their senior representatives. He had extensive experience in the knowledge of modern American politics and the role the media therein, and had written widely on modern American politics, including an ebook, The War on the Internet, and a variety of different articles. I'm not going to read them. So they're all the articles there, okay, that he's written. So what they're trying to state is that he's a very well-educated, well-rounded, had previously written on Mr. Trump and the role of Fox News in the United States, including in books. And again, here's his books that he wrote. And then articles that he wrote on. Had closely followed the events from the 2020 presidential election to the present day, and in particular had reviewed the vast amounts of media commentary concerned with the role of Fox in the January 6 riots, including but not limited to. So this article by Brian Stetler, Fire Hose of Falsehood. Oliver Darcy, the right-wing media gathered the tinder, and so on and so forth. Here's Kevin Rudd said Sky News is using the Fox model to radicalise politics in Australia. Yeah. Malcolm Turnbull is speaking to the Senate inquiry into media diversity in Australia. Will a boycott knock Tucker off air? Don't count on it, etc. So here's all the articles that he's read. He was aware of the detail of the case had been brought by Dominion against Fox News in connection with the next week's claims of widespread fraud. Had read the substance of evidence given by Ms. Hutchinson on the 28th of June 2022 and was aware of the facts set out in paragraphs 1 to 15 above. Mr. Keane included the reference to Murdoch-owned Fox News in the article because he was comparing Trump's actions on January 6 to Richard Nixon's involvement in the Watergate scandal. Included the phrase unindicted co-conspirator as a reference to President Nixon, who was described by a grand jury as an unindicted co-conspirator in the conspiracy to cover up the Watergate bungle. Believed a key point of distinction between President Nixon's and Trump's was that there was no media outlet like Fox in the 70s. Was of the view that Fox has played an essential role in amplifying the division that Trump had caused, and felt that any discussion of 6th of January would be recklessly incomplete without an understanding of the media environment in the United States. Both Mr. Frey and Mr. Keane firmly believe that the references to Mr. Murdoch were a statement of Mr. Keane's opinion based on his knowledge and extensive reporting of Fox News' involvement in the events leading up to the January 6th and the Murdoch's role in guiding minds of Fox editorial strategy and programming. The references to the Murdochs to be self-evidently hyperbolic, using creative license to pick up on the notorious identification of Nixon as the indicted co-conspirator in Watergate and drawing a parallel to the January 6 riots. No one would read the words literally as suggesting that the Murdochs were guilty of criminal conspiracy or treason under US law. Neither Mr. Frey nor Mr. Keane considered it necessary to contact Lachlan Murdoch for comment because he was not the target of the article. Murdoch, referring to the family or Fox News generally, the article was an opinion piece, not news reporting. At the time of publication, respondents were conscious of the importance of freedom of expression in the discussion of matters of public interest. As to paragraph 1 of statement of claim, the respondents do not know and cannot admit whether Lachlan Murdoch is an Australian citizen, otherwise admit their allocations containing paragraph 1. So now they're going through and saying what they admit and what they don't. So we're just going to go, we're just going to quickly, so I'll just let you have a read of that. You're doing all right, Bella. So that, you know, they deny stuff, they admit stuff. They deny, they admit, and they, you know, in answer, admit that reposted the article. Admit, but, you know, so they've just going through and saying, we deny this, we admit this, we deny this, here's an explanation. Do not plead as they contain no allegations against the respondents, so they're not going to plead it. Do not know and cannot admit. So they do not admit that from the 29th of June 2022 to August 15, 2022, the article was and concerning Lachlan Murdoch, and admit that from the 15th of August 2022, the article was of and concerning Lachlan Murdoch. Hello, Vedandra. Again, so now they deny allegations of serious harm, and then this concerns notice. So this is how it's all done. That found it which is denied. So it says further, if which is denied. Oh, Lachlan Murdoch. Have you heard of Rupert Murdoch? From Fox, he owns Fox. That's who it is. So it's that family. So they're saying that if which is denied, Lachlan Murdoch is found to be entitled to any damages, they rely on mitigation in damages. So, and here's their mitigations. So they go, we don't think that we're liable, but if we're found to be liable, this is what we're going to plead. The matters alleged in paragraphs 1 to 22, the facts, matters, and circumstances proven in support of the defences, the bad reputation of Lachlan Murdoch amongst the Australian people for his role as CEO of Fox News, a conservative media channel providing biased reporting in favour of conservative political positions, and News International, an organisation that engaged in systematic unethical practices in investigative reporting. Whoa, they won't like that. So they're saying that Lachlan Murdoch's already got a bad reputation because of Sky News, the circumstances in which proved the matters complained of were published and following discovery. So injunctive relief, and here's their defences. So by the reasons of the matter set out in 1 to 22 above, if the matter complained of is found to be defamatory in that it contained one or more of the imputations, which is denied, the respondents say the article concerned Mr. Trump's conduct in connection with the election of November 2020, the state of the American democracy, the polarization within American politics, borne out by the events of January 6th, and the media environment in which those events took place, all of which were public interest. Reasonably believed that the publication of the matter was in the public interest, and in the premises, publication of the article was in the public interest and therefore defensible pursuant to Section 29A of the Defamation Act 2005 and its equivalent state and territories. So there was an amendment made that came into effect last year, that there is actually a public interest defence in defamation proceedings. So defence laying qualified privilege. Further, and in the alternative, if the matter complained of is found to be defamatory in that it conveyed one or the more imputations, which is denied, the respondents, in reliance of paragraphs 1 to 23 above, say that the matter was published on an occasion of qualified privilege, being implied constitutional freedom of communication about governmental or political matters. So so essentially what they're saying is, if it's found to be defamatory, which we say it's not, if you're going to find it that it's defamatory, then here is our defence. Failure to accept reasonable offer of amends, Section 18 of Defamation Act. If the matter complained of is found to be defamatory, or that it conveyed one or more of the imputations, which is denied, the respondents say that on the 27th of July, 2022, by their solicitors, Mark Lawyers, they made an offer of amends to Lachlan Murdoch pursuant to and comfortable with Section 13 of the Defamation Act 2005. The offer of amends was made as soon as reasonably practicable after they were given a concerns notice in respect of the matter, and in any event within the applicable period for an offer to make amends. The respondents were ready and willing on acceptance of the offer of amends by Lachlan Murdoch to carry out the terms of the offer. In all the circumstances, the offer of amends was reasonable. On the 29th of July 2022, the offer of amends was rejected. In the premises, the respondents have a defence pursuant to Section 18 of the Defamation Act. So this is the defence. So they got to reply to that. Now we know that Sue Chrysanthu is the barrister, and then we're going to have a look at some of the stuff that says. So this is the response from Murdoch to private media. Private media has, on the face of it, put up standard defences. The public interest defence is going to be very interesting because, for me, the question is, where did Australians really care about what happened in the US? So that would be where it could be argued. And then, because it's US politics, not Australian politics. Anyway. So this is in answer to the defence filed on the 20th of September. Murdoch adopts the same defined terms as appear in the statement of claim following the 23rd of August and relies upon the following facts. Save and except for, as far as contains admissions, including deemed admissions or as otherwise expressly pleaded in his reply. Murdoch joins issues with the matters pleaded in defence and relies on the matters pleaded in the statement of claim. So he's saying he doesn't like it. In answers to paragraph 1 to 16 of the defence, factual background, Murdoch says that they are embarrassing and irrelevant to any fact in issue other than to the extent that they were matters in the minds of and believed by any private media, Frey and or Keane at the time of publication of the article. In responses to paragraph 17 to 22 of the defence, conduct of Keane and Frey, they are embarrassing and irrelevant to any fact in issue other than the determination of defences pleaded in paragraphs 42 and 43 of defence. I don't know that you could say that they're irrelevant, because if the facts, if without the background of what went on with the US election, then you don't have any context for the article, in my opinion. So I wouldn't say that they're irrelevant or embarrassing. Anyway, in answer to paragraph 37 of defence mitigation, Murdoch says that the matters pleaded in subparagraph 37.1 are embarrassing, ambiguous, and disclose no reasonable ground of mitigation. And of course, this is how they have to respond. So in plea 2, so paragraph 30 is embarrassing, in the absence of any justification or honest opinion defences. Okay, so they're saying they haven't given a defence of honest opinion. I thought they said there was an opinion. The plea in 37.3 is embarrassing in bad form in that it breaches the rule in Scott versus Sampson, fails to identify any relevant sector of Murdoch's reputation, is ambiguous, and discloses no reasonable ground of mitigation. Now, that what they're talking about there is they said we're sitting there that he has a bad reputation because of Fox or Sky News. And 37.5 is embarrassing, to be irrelevant to any ground of mitigation. So now they deny that the article's defamatory matter about Murdoch is a concern of public interest. They deny that the article is of public interest, and denies that any of private media, Frey or Keane, reasonably believed at the time of the publication of the article, to the extent it carries defamatory matter about Murdoch, was in the public interest. Denies. So they're essentially, it's not public interest. Now they're saying that it was malice. Says that in publishing the article, private media, Keane and Frey, were instead actuated by malice, in that they predominantly acted with the improper purpose or purposes of harming Murdoch and or seeking to attract unwarranted attention to the article by using Murdoch's name as evidenced, set out in paragraph 7 below. But my understanding in the article is that he used the word Murdoch. It could have been anybody, any of the Murdochs. In answer to paragraph 43 of the defence, Murdoch denies that the article concerned governmental or political matters by reason of the implied constitutional freedom of communication about such matters. In further to answer paragraph 43 of the defence, Murdoch says that in publishing the article, so we've got the malice again. Now they're trying to say that they didn't adhere to journalistic standards. So private media and or Frey promote the Crikey website as a legitimate news source, publishing articles that serve a public benefit and are of public interest. Frey and Keane promote themselves as journalists who write articles for Crikey website that serve a public benefit and are in the public's interest. Isn't that just contradictory to what they're saying, that it wasn't public interest, but now saying that they say that they, Eric Beecher, chairman and major shareholder of private media, has claimed the article was public interest journalism. Private media, Beecher, Frey, Keane, and now they've brought in another party, claim to adhere to a code of conduct in their reporting that is said to reflect the standard of conduct required by the Media, Entertainment and Arts Alliance, including seeking truth and providing a fair and comprehensive account, thorough and honest reporting. On a side note, are we really going to start talking about media outlets and whether they adhere to codes? Because let's put Murdoch, let's put Sky News there. Anyway, thorough and honest reporting, acting with professional integrity, striving for accuracy, fairness, and disclosure of all essential facts, not distorting emphasis, giving a fair opportunity to reply, not allowing personal interest, belief, payment, gift, or benefit to undermine accuracy, fairness, and independence. Vedandra, it does sound like I know you are, but what am I? It really does. Okay, so in publishing the article, they're saying that they failed to adhere to the standards of here. And private media is a member of the Australian Press Council. And in publishing the article, the circumstances described further failed to adhere to the Australian Press Council's statement of principles. Public interest journalism requires at least it concerns a topic of public interest. It includes original investigations such as primary documents, interviews, and original material. Claims of fact, transparent and verifiable, is presented in a clear, fair and balanced manner, minimises harm and allows the right reply. By reasons and matters described further. Hello, Bella. Thank you very much, Bella. So they're saying that. So now they're saying that they've refused to adhere to the principles. I'll make it bigger so you can read it because it's very repetitive. As you can see, very repetitive. This one was we're not acting for the public benefit or in order to protect public interest journalism. They're saying that it was hypocritical and cynical scheme to harm Murdoch, boost subscriptions and gain publicity, and or engender sympathy. So they're saying that in this reply was part of a premeditated marketing campaign to publish articles for the predominant purpose of encouraging and soliciting subscriptions. The article purported to concern evidence given by Cassie Hutchinson on the 28th of June 2022 about the conduct and knowledge of Donald Trump on the 6th of January 2021 and the days preceding it. To the knowledge of private media, the Hutchinson evidence made no reference to Murdoch or any person in Murdoch's family or with the same surname. To the knowledge of private media, the Hutchinson evidence did not concern any allegation about Fox News conspiring with or supporting Trump. The only references to Fox News the days Hutchinson gave evidence were made by Liz Cheney, who mentioned 2 Fox News personalities that sent texts and other entreaties to Mark Meadows to ask Mr. Trump to tell people in the Capitol to go home. So evidence aired on Fox News. So it all falsely implied that Murdoch had been named in the Hutchinson evidence. The article falsely implied that Murdoch had been named in the Hutchinson evidence or other evidence before the Senate Select Committee as a co-conspirator of Trump. Anyway, that Murdoch be identified as one of the subjects of the article. So we're going through this. Murdoch or any person with his surname collaborated with or conspired. So they're saying that they deliberately chose to use the term unindicted co-conspirator in conjunction with the name Murdoch, combined with the allegation that he committed indictable crimes in connection with events of January 6, 2021, consistent with the marketing campaign adopted to attract subscribers. Had knowledge of the falsity of imputations carried by the article about Murdoch, as admitted on their behalf by their solicitor Michael Bradley in a letter dated 27th of July, in which they accepted that there is no evidence that Murdoch engaged in any of the conduct subject of the imputations. No attempt was made by any of the private media, Frey or Keane, to conduct Murdoch or any person in his family with that surname prior to publication to give him the opportunity to respond to the allegations. Upon complaint, that they removed the article within 20 minutes. That one, through their implicitly accepted that Murdoch was identified by the article, but not by the social media posts. They're saying through their solicitor that they admitted the article mentioned Murdoch. That They didn't make any claim that Murdoch was not the subject. The 14th of August, when speaking for a quote in the Sydney Morning Herald article, Freeman made no claim that the article was not about Murdoch. So we've got that. So now we're talking about harm. Oh, thank you, Bella, again. Including Murdoch's name in the article was to the knowledge of private media, Keane and Frey, irrelevant and unnecessary for the reasons set out above, and it was ordered to increase readership. So they're saying that essentially they just put in Murdoch's name just so that they would get people to watch, to subscribe to their subscription service. Okay, and it was to increase the readership. It was to draw attention, and then to draw attention to a dispute that ended some 10 days earlier, to falsely claim that they'd been intimidated and to attract subscriptions. Shortly after reposting the article, they offered a half-price subscription offer, referring in that advertising to its dispute with Murdoch. They paid up to $100,000 to place the New York Times, demanding it and Frey and Eric Beecher be sued by Murdoch for their publication. They paid thousands of dollars for ads. So they're going through they're just reiterating. So engendering sympathy in order to harm Murdoch. So prior to publication of the article, private media received a revenue of approximately $3 million from subscription to Crikey. Shareholders of private media include wealthy business individuals with some assets over tens of millions of dollars. They're saying that they're insured for defamation, which will indemnify it for its costs, and that none of private media, Frey or Keane, have disclosed the insurance policy to the public. Since the 14th of August 2022, they've made social media posts, given interviews, set up a GoFundMe, and again, they're reiterating, Murdoch could not sue in the US because he's a public figure. Murdoch sought to intimidate him. Murdoch sought to bully them. So, yeah. They are David or David's weaker younger sibling in a battle against Goliath. And then they're saying that Will Hayward, CEO of private media, falsely claimed in an article on the Crikey website, huge bet for sure, but we believe a free press is worth fighting for, that Murdoch brought the claims that Crikey should suffer, and it is our subscribers versus Murdoch's billions, falsely representing what these proceedings are about in order to engender sympathy to private media and incite hatred towards Murdoch, including on the 24th of August 2022 in an article written by Keane, the events of January 6th and the role of Fox and the Murdochs must be scrutinised. So now they're talking about their GoFundMe campaign, seeking $3 million, which included a representation that the cost to respondents could be millions in damages and legal costs, when in fact they are insured by reasons of private media's resources, including insurance policy, the representations made to the public in order to generate new subscriptions and donations were false. Again, I think they have to prove that. Hello, Bo. In answer to paragraphs 44 to 49, Murdoch says the letter of January 27th of July did not constitute an offer to make amends. The offer was not made as soon as reasonably practicable after the provision of the concerns notice had been issued 4 weeks earlier. In circumstances where respondents removed the article from the Crikey website, and by their lawyers, in fact, responding to the concerns notice, the offer was not reasonable in the circumstances because of reasons set out in a letter from Murdoch's solicitor dated 29th of July 2022, it did not offer to publish a reasonable correction or clarification. The statement repeated verbatim the offensive defamatory content from the article, which had been taken down from the Crikey website 4 weeks earlier. The statement set out defamatory imputations of concerns to Murdoch. It did not include an offer to reasonably take steps to tell third parties that the matter is or may be defamatory to Murdoch. It did not include an apology. It included further allegations about Murdoch. Murdoch repeats and relies on matters set out in the proceedings, paragraphs 6, 7, and 8, as matters within his knowledge that have aggravated the hurt and harm occasioned him but by the publication of the article. So they're saying that on social media accounts by private media Fray Keane, Will Hayward, and Mark lawyers, and in interviews about the proceedings, they've attracted comments about Murdoch and his lawyers, complaining about Murdoch's commencement of the proceedings, having demanded that he will sue them in relation to the article. The hypocritical failure of private media to upload the statement of claim onto the Crikey website, having claimed it sought to be transparent in uploading the pre-litigation correspondence, and having claimed that it welcomed honest, open, and public debate about its dispute with Murdoch and these proceedings. Well, we got them from the federal court site. So falsely representing that these proceedings are about, including the 24th of August 2022 article written by Keane and published on the Crikey website, alleging that on the 24th of August 2022, in an article written by Michael Bradley, published on the Crikey website, Australia's defamation laws favour the reputations of the rich and powerful. Why? That Murdoch and other public figures who commenced defamation proceedings in Australia could not have done so in the United States of America because of the requirement of malice in circumstances where Murdoch did, in fact, allege malice against private media. The other applicants referred to in the article either proved malice, hockey, proved conduct amounting to malice, where a malice finding was not the issue, Barilaro. Why does he keep coming back into everything? Barilaro! Or otherwise alleged malice. The article failed to refer. Remember, it's the same barrister, Chris Anthu, and I think she represented hockey as well. I think she was the lawyer for hockey. She's definitely the barrister for Barilaro. The article failed to refer the reader to statement of claim or excerpt those parts of it which alleged malice. The article advocated for a change in Australia's defamation laws to provide a defence for impunged publication concerning government or politics, only to concede that such a defence would still have an exception for malice. Making offensive and inappropriate comments about Murdoch's solicitor, the commencement of a GoFundMe campaign on the 26th of August seeking $3 million, which included a representation that the costs to respondents could be millions of dollars. In fact, they had insurance, alleging on the 6th of September 2022 in an article published on the Crikey website titled, "Why Do Billionaires Slap Journalists? Because They Can," that Murdoch's claim is an abusive process, and so were the other proceedings in which his senior counsel were briefed. So, and then again, they have to file this to say that they've done that. Right. So today they went to court. So this is Twitter on the Murdoch case today. So let's have a look what Twitter's got to say. Lachlan Murdoch's barrister has come out and accused Crikey of mocking my client. Isn't mocking people what Murdoch does? Murdoch bases his whole News Corp business model on. The Lachlan has been fixed to begin on the 27th of March 2023. So that is when it's going to be held. The 27th of March 2023, we're going to have the full defamation case. Rupert and Lachlan Murdoch, why do you continually put Douglas McGregor on Fox News to spread Putin's propaganda and lies? This is absolutely not in America's interest. Lawyers for Lachlan Murdoch have told a Sydney judge the company which owns Crikey has been directing ridicule and hatred towards him. Forgive me if I'm wrong, but isn't ridicule and hate the bread and butter of News Corp? Feeling sad for Lachlan Murdoch, imagine how awful it would be to be mocked and ridiculed by a media company. Lachlan Murdoch's barrister says Crikey mocked poor Lachlan. Wonder how many Twitter people he could sue for mocking. He hasn't seen mocking yet. An article published in Crikey linking the Murdoch family to Delhi US Capitol riots caused Lachlan Murdoch serious harm, and any suggestion to the contrary is farcical, his barrister has argued. Apparently, Lachlan Murdoch said that Crikey's conduct is part of a conspiracy or scheme to cause him harm. Lachlan Murdoch is suing Crikey News for apparently mocking him and his family. Rupert became a billionaire for doing that. So this be Crikey, the other be Lachlan Murdoch. Be Crikey, don't be Lachlan Murdoch. So it says, Dear America, now I've got your attention. We'll make a deal. If you must look up an Aussie for publishing, then why not take Lachlan and let Assange go? You can take Dad for free. No backsies. Love Australia. I reckon only News Corp will do that first, Lachlan. Mr. Murdoch needs to sue himself for bringing himself into disrepute and causing himself irreparable damage by owning News Corp. So it begins. The favourite tactic of Lachlan Murdoch's monopoly is to assassinate the character of those who challenge their power. Simple fact, Australia has the most monopolised media in the democratic world. And then, so they've attacked somebody that's speaking it out. If Lachlan Murdoch is worried about his reputation, why is Fox News and News Corp continuing to publish Trump's lie that the election was stolen? Crikey is right to call out Murdoch's role in the insurrection. Murdoch is wrong to try and silence small media companies critical of him. Lachlan Murdoch claims he was defamed after the article referred to the Murdochs and Fox News commentators as unindicted co-conspirators in the Trump insurrection against democracy. At times, the truth and uncomfortable Guardian reveals flaws. Lachlan Murdoch versus Crikey case kicks off this Friday in federal court at 9 a.m. I'll live tweet this. The court has opened a public file online. Yeah, I know. So anyway, so it goes, and so it goes, and so it goes. Michael West Media said, wrote an article how, while Crikey might actually lose the battle, they'll lose the court of public opinion. So here we go. So here's the article. So lawyers for Lachlan Murdoch has told a Sydney judge the company which owns Crikey has been directing ridicule and hatred towards him and publicly claiming martyrdom as a date is set for his defamation trial. The Fox Corporation CEO is suing private media in federal court over an analysis article published in June about the hearings into the deadly January 2021 insurrection on the Capitol by Donald Trump supporters. As matters came before Justice Michael Whitney for the first time, barrister Sue Chrysanthou, SC, from Mr. Murdoch, took issue with the conduct of her opponents over the past month. She said the CEO of private media had this week published a video purporting to explain their defence. It would appear had a response to portraying the proceedings and are portraying what is in fact in issue is very different to what the pleaded issues are, she said. There have been a number of effects, including no doubt increase in subscriptions and money paid to a GoFundMe account that have been set up, but also directing ridicule and hatred towards my client. Ms. Chrysanthou said billboards had appeared in Melbourne, which were paid for by the respondents. People have publicly claiming martyrdom for the last 4 weeks because they're being sued by somebody wealthy where they mock my client on public billboards. Justin Whitney set a 9-day hearing, 9 days, to begin on March 27, but also said he will at some point direct the parties to attend mediation before a registrar. Cool commercial minds may prevail, he said. I admire your honour's optimism, Ms. Chrysanthou said. In defence documents, private media denies the articles were defamatory. We know that because we've just read it. Raised 3 defences, including a new public interest defence. The article concerned Mr. Trump's conduct in connection with the election of November 2020, the state of American democracy, and the polarisation with the American politics borne out by the events of January 6th and the media environment in which those events took place, all of which were matters of public interest, documents say. They also flagged defences of implied constitutional freedom of communication about political matters. The defence documents say the phrase unindicted co-conspirator was included as a reference to President Nixon, who was described by a grand jury in the same terms in the conspiracy to cover up the Watergate bungle. Editor-in-Chief of Crikey, Peter Fray, and political editor Bernard Keane believed the references to Mr. Murdoch were a statement of Keane's opinion, based on his knowledge of the extensive reportage of the Fox's News' involvement in the events leading up to the January 6th and Murdoch's role as guiding minds of Fox editorial strategy and programming. They also believe references to Murdoch's were self-evidently hyperbolic, using creative license to pick up on the notorious identification of Nixon as the unindicted co-conspirator in Watergate. Private media argues that nobody would read the words literally, as suggested that the Murdochs were guilty of criminal conspiracy. The case returns to court on October 10. So let's just go back here. Look, chat was frozen. I'm sorry to hear that. So let's go back here and see what we've got. So this is the court file here. So they had their first case management today, and we've got the interlocutory hearing. So they've just released the defense and the reply. So there's been an interlocutory application and an affidavit filed. I don't know what the interlocutory application is, but there's an interlocutory hearing on the 10th. So let's see if somebody else gives us the information. No one's given us the information about what the A multimillionaire of a media company suing someone because they felt mocked is the most strident effect Christian Portering thing Lachlan Murdoch could possibly do. I see no mocking of Lachlan Murdoch on those billboard signs. Mogul-free journalism, fearless news and views daily, not for the thin-skinned, mocking, showing ridicule, contempt, and derision. I regret to inform you, Rupert and Lachlan Murdoch do not give a damn about America's interests. That the evidence X years ago is overwhelming. So yeah. So anyway, that is where we are at the moment with the Murdochs. So yeah, so that's what's happened with the Murdochs. Now, what happened today? Friendly Geordies was back in court. Our mate, Friendly Geordies. He was back in court today. I think the best way to describe this is to have the great man tell you himself. Let me just pull up his channel. So he did a report with a whistleblower on Clubs New South Wales, and he's actually been charged with contempt of court. And so our mate Jordan Shanks has done what he knows best and has decided to make a video on it. I found it quite entertaining, to be honest with you. It's called, if you haven't seen it, it's called Friendly Geordies Goes to Court. All right, here we go. Friendly Geordies Goes to Court. Let me just pull this up and we will have a look at it.
Oh, well, look who suited up, hey? Me and the Iron Man. Well, that was supposed to go on my head. Would have been very cool if that happened, but we have done many takes, and we tried that for an hour. It didn't work. The reason we're here is because of Clubs New South Wales again, the gambling lobby, ruining my life because they're running a private criminal prosecution against me for contempt of court. I never thought I'd have to say that sentence. I didn't even know that sentence was possible, but here we are. What a world. It was over a whistle.
Oh, you were going to watch it when you saw that I was live? Yeah, so him and this Troy shot, this Troy is got this. So he also refers to an article, I think it's one of these ones as well, in Independent Australia. The Media Watch versus, yeah, there's a few articles on the Independent Australia website. So, all right. Oh, you're going to find, he's going to explain it, Bella. He's going to explain it to you.
Whistleblower video about Troy Stoles, a man who used to work for clubs, then blew the whistle on appalling levels of anti-money laundering compliance at their venues. Club sued him. He's been forced to sell his house because of it. He is now dying of cancer. Christo interviewed him about it. And because of that interview, Clubs New South Wales launched a prosecution against Troy and me.
So the interview, as you can see, has been taken down because of a court order. The court had said. So Christo did the interview, and Friendly Geordies has been charged with contempt of court.
What the At first, there was an interim suppression order. Clubs were trying to keep their prosecution entirely secret, but now that order's lifted, and that was my first day of court. Good for me. And so I thought that we'd vlog it. It's not every day that you get prosecuted by the gambling lobby, is it? So I hope you enjoy that. I most certainly will not. And yeah. Just we tried to get an even dumber suit than this, but it didn't come in time in the mail. And also, I had COVID for a week. We're going to do something a little fancier than this, but now.
So yeah, so he essentially he published an interview from a whistleblower from the gambling lobby, and there was a court order that had to be taken down, and now both of them are being done for contempt of court. And the same lawyer that represented Christo is representing both of them.
We can't, because I just walked out of isolation and now I'm going into court. Thanks, Clubs. What is it with you and sick people? What have you done? I didn't do nothing. I truly do believe that, though. And I think that has been ruined as a plea from so many murderers over the years.
I find it very interesting that he's just sitting in the back seat of a car. Yes, I did check my Twitter just before.
Hey, but they're innocent and still probably convinced of it while they're in jail. So I know that nobody does believe me. I know that you think I'm crazy for saying it, but I don't care. I'm sticking to my story, and that's that. Clubs New South Wales thinks I'm guilty of... I don't know. I wasn't there. I really don't understand.
So they're saying that he was not present at the interview. That got him in trouble.
I want to go to court. I feel like I'm too stupid. I feel like one of those guys that has the intelligence of a 5-year-old going to court being like, are we going to school today, mommy? Like, I don't know what I'm there. We're going in to do a directions hearing. And in a directions hearing, I think that's where you plead either guilty or not guilty. Now, I don't know when they put the handcuffs on me or if they put them on me at all. I hope that they do. And I really hope it's those handcuffs that have the other chain that comes down, I think, from your neck as well.
So the directions hearing is where they will just, because it's a private prosecution. And yeah, so he'll essentially say whether he's guilty or not guilty, and then the court will set some new dates, and yeah, we move on from there.
Because I really do feel like this will add to the aesthetic of me just walking in like I own several orange farms along the Amalfi coast, and to make it just be like, he is the most dangerous 80-year-old the world has ever seen. And then me to just walking in, shuffling in, being like...
I'm impressed he's even talking about wearing a hat to court, actually.
You're that Elizabeth, darling. Oh, you can? Well, should have asked anyway. Flooring big butt. I don't get it. It's a low way.
I missed that. Did you see that? Wait on. Flooring big butt.
Flooring big butt. I don't get it. It's a long way to the top if you want to rock and roll. What has this got to do with court? It's the long way to the top if you want to. This doesn't make any sense. Only.
So he had Christo go to court too with him.
God can judge me. Anyway, let's go get judged. There we are. Ye old federal court. The oldest court there is. All right, what do you think about this, guys? Is it too much of a stretch to say that Troy Stolz is Jesus? I'm one of his loyal disciples. Judas? No, I'm Judas. I'm the cool one. I've really got to brush up on who the 12 apostles are than any others. That's all I've got. Yeah, I'm starting to realise I don't know Sydney as well as I thought. We were going to do a tour, but I forgot. We don't even know. Is it court down this way?
Yes, he's lost in Sydney at the moment, which I find to be quite amusing.
That's
We're going there.
That's the criminal one.
Yeah.
So that's usually
our usual.
Their usual haunts the criminal court.
There's also the usual one, but it's online usually.
And then there's the other one that was online.
Oh, is this the place? Yeah. Finally, God. You know what I feel like now? I feel like when you've just been watching a Twitch stream for too long and you actually see them in person.
Don't meet your heroes.
And there is the court building, the Federal Court of Australia. That's where they're off to. Oh.
So it's that ugly 80s one there.
Yeah.
There we go. That's the Federal Court building.
Now, because I'm a respectable man, I done best take off my hat. Sorry, ma'am.
Okay. So, of course, he wasn't ever going to be able to film it.
Well, there you have it, folks. Not guilty is what I pleaded. We don't know what the verdict will be. That'll come sometime next year. But the point is, I maintain my innocence, and that has been put on the record today. And that's all I can say about it, because I didn't realise that our time in court would be that quick. We were in there for like 2 minutes, bam once, and then sat down and they just went, yeah, what do you think? Not guilty? Yeah, well, yeah. Do you also think that you're not guilty, Troy? Oh, okay. All right. Well, court adjourned. I got in a suit for this.
He put on a suit for 2 minutes.
Feeling cheeky? Might go to court later. Hashtag not guilty thieves. This is Christo's coffee. I'm not allowed to. Sorry. Oh man, that really worked up an appetite. Me being in court for several minutes. I guess it's time for. It's been a couple of hours. We're going to get something going. The papers call me a racist. But would a racist order this? That's right. I'm doing what the press doesn't do. I'm asking the questions. Well, that was a fun day, wasn't it? Not for me. It was extremely tedious and nerve-wracking. However, we will be doing an actual breakdown of what is going on in my fight against Clubs New South Wales. How did my life get to this point? But we will be doing something about that in more detail. But I have had COVID for the last week, so I think you'll excuse me just walking around and going, oh, that's a nice frangipani over there. I'm still a bit woozy, okay? So you are just going to like this video and you're going to subscribe, because you're going to be polite to me for once, because I've had a very rough day. And we'll do more of these vlogs as well. Just, you know, I mean, come on. It's content. Oh, look what's over there. What a coincidence. We didn't have to go this way. It just panned out.
He's going to do a show at Paddo RSL.
Yeah, I'm doing my show at Paddington RSL. Yes, the best RSL in Paddington. And also I like the fact that it's just sticking there as this working class rough refuge for, I don't know who anymore, but I just like how the rest of the street is just independent cinema and that. And that's where you're going to be seeing me, none of this palace crap.
All right, so that is what happened today for Friendly Geordies in court. So it's been a big day in court. What I want to know is whether he saw Sue Chrysanthou and Murdoch and his lawyers as well. It'd be interesting. But anyway, so that's been everything that's happened today. So that's pretty good. For poor FJ, yeah, it's funny. Yeah, it's interesting that he just look. He's got a good sense of humor about it. His lawyers, just think it's a joke. And as I said, that Troy guy, he doesn't have very long to live either. So, which I find to be quite disconcerting that they're still going after him. I know. So make sure that you go. Make sure you go and support him, support his channel, and hit like and subscribe. So they shared. So his lawyers today shared a. This was. This is the law firm's Twitter. So it says it's remarkable that a private company like Clubs New South Wales can initiate a criminal proceedings. This has been a secret for the past month. A suppression order lifted today. We are acting for both Troy Stoltz and Jordan Shanks. There's been a suppression order. We act for both Troy and Shanks. The fact that both of them are now facing jail through a private prosecution is extraordinary for us, and we'll fight it at every turn. So that is what's happening. There's been So I will put the links to those articles in the if you want to have a read. I'll just put the links in there, and you can have a read and find out a little bit more about the stuff. Yeah, and I'll also put the link to Friendly Geordie's channel too. So that's the story on the what Shanks has got in trouble for. Look, some background, and that's what the lawyer was sharing today. And I will put the Friendly Geordie's channel information in here as well. And I have to be up earlier tomorrow because I've got to go catching public transport tomorrow, and I've got to leave home at 5 a.m. in the morning. So I'm going to need to head off and so I can get some sleep because I'm still pretty sore. I'm still feeling pretty sore. It's been big days. All right. So we've got the article and we've got the channel for Shanks. So make sure that you watch it and keep up with all of his stuff. And I'll keep you updated with everything that's going on around the place. For those of you that like the Katie Joy stuff, we will have a discussion about what's happening there because there has been an extra court date put into 7M, and it looks like the court has set a date for a default judgment to be determined. So, and it doesn't look like she's filed a defense yet, which means that 7M can file. I have not, and I think he was channeling Colonel Sanders, Bo. I think he was channeling Colonel Sanders. Sanders. I think it was a bit of a satire. So we'll have a look at that. But it looks like 7M might be filing a default judgment against Katie Joy because there's been no defense filed. So we'll have a look at that too. What that all means. So so thank you. Make sure you hit like and subscribe. Ring the bell so you get an idea of when I go live. Sometimes I just decide to go live. I just not long woken up from my nap after work, and I thought, and I was reading all the stuff, and I thought, they've released all the court documents. Let's go through those. So hence why. I know, Bo. I'm not one for fashion, so. And the other story that I shared was that some of the footage, John Barilaro was charged with assault against that cameraman, and some of the some of the evidence was deemed inadmissible because of the way it was obtained. So the police actually have to go and re-subpoena the video footage and do it properly for the court to, otherwise Baralara is going to get off. So, but it's funny how his name comes up into everything. How his name comes up into everything. It came up in the document in the Murdoch case. Oh, good. Thank you, Bella. Yeah, as I said, I've just I've been reading a few, but there is an extra date. There's a date in November, so that's been added. So I'm just trying to work out what's going on, and but there's been no other documents filed yet. So, all right. Well, as I said, make sure you hit like and subscribe, and thank you for watching, and I'll catch you next time. All right.